Hi friends, I am your friend advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, in today's time, the family disputes, the matrimonial disputes is increasing day by day. There are many reasons that these disputes are increasing, but family court, before granting the decree of divorce, used to make efforts to make settlement between the husband and wife so that their matrimonial life may not disturb. So in this video, we would like to study section 23(2) of the Hindu Marriage Act. We will also study section 9 of the Family Court Act 1984. Before I proceed further with my video, if I would like to request that if you have not yet subscribed my channel, please subscribe my channel, and if you like my videos, please share my videos. Friends, matrimonial disputes are increasing day by day because the tolerance power are becoming gradually decreasing in the husband and wife. They both are working, they are having the less tolerance power, they are becoming egoistic day by day, and that is why the matrimonial disputes are increasing. So what are the reasons that many time husband and wife, even after 7 days, they want that their marriage should be dissolved and they want to get a degree of divorce. Many time I received a call, even after 7 days, after 10 days, after they used to call me that sir, we want a degree of divorce. But Hindu marriage is a sacrament. There is a provision of law, section 14 of the Hindu Marriage Act, that neither party can seek a dissolution of marriage before a lapse of one period of 1 year of their marriage. So at least they have to wait for a period of 1 year. So why the matrimonial disputes are increasing? Change in lifestyle, less moral values, and influence of social media in day-to-day life. They are becoming less social and they are becoming more social media friendly. So Hindu marriage is a sacrament. When a petition filed by before a family court, the family court used to issue notices to the parties. If either party file, supposedly husband file a petition for seeking dissolution of marriage, the family court issues notice to the wife. When the notice is served and she appeared, then family court used to make efforts for settlement. They used to send the matter before the mediation, and the conciliation talks used to the conciliation officers used to talk to them, and they tried their best that their marriage should not be dissolved and matrimonial life should not be disturbed. What are the legal provisions? So I would like to read section 23(2) of the Hindu Marriage Act. Before proceeding to grant any relief under this act, it shall be the duty of the court, in the first instance, in every case where it is possible so to do consistently with the nature and circumstances of the case, to make every endeavor to bring about a reconciliation between the parties. What does it mean? It means that before granting a decree of divorce, after receiving the petition, and before granting the decree of divorce, it's a duty of the court to try to settle the dispute amicably, because differences may arise when a husband and wife is living together. So the family court does not grant at the first instance the degree of divorce. They used to make an efforts. The mediation cell has been established and well trained mediation officers are there. So they used to convey to both husband and wife that it's not a better recourse to take a divorce. Instead of taking divorce, you can live together if you both are ready. If they both are not ready, then the only recourse is available is to the decree of divorce. Section 9 of the Family Court Act 1984 says duty of family court to make efforts for settlement. Almost the same language which section 23 subsection 2 says. What section 9 says, I would like to read section 9. In every suit or proceeding, endeavor shall be made by the family court in the first instance where it is possible to do so, consistent with the nature and circumstances of the case, to assist and pursue the parties in arriving at a settlement in respect of the subject matter of the suit or proceeding, and for this purpose a family court may, subject to any rules made by the High Court, follow such procedure as it deems fit. Meaning thereby that the family court can follow the procedure subject to the rules made by the High Court to settle the dispute between the parties. the subsection 2 says, if in any suit or proceeding at any stage it appears to the family court that there is a reasonable possibility of a settlement between the parties, the family court may adjourn the proceedings for such period as it think fit to enable attempts to be made to effect such a settlement. What does it mean? Supposingly, one party file a petition, second, the opposite party files a reply, then evidence also completed. Even at the final hearing stage, if it seems to the court that there is a possibility of settlement, the court used to make that efforts. And a party can also move an application. How to draft that application? The party should first write the name of the court, then petition number, then cause title, then application under section 23(2) of the Hindu Marriage Act for amicably settlement of the matter. Then the party should write that there is the divorce petition is pending, there is possibility that the settlement can be take place between the parties, so the court may make an efforts through a mediation cell, so that the matter can be resolved through a mediation cell. Now the question arises is, what is the case laws of the Honorable Supreme Court with this aspect? So the apex court in Jagraj Singh versus Birpal Kaur reported in JT 2007-3 SC 389 observed as follows. I would like to read the observation of the Honorable Apex Court. The Act Hindu Marriage Act 1955 is a special act dealing with the provisions relating to marriage or divorce. Subsection 2 of section 23 expressly states that where a petition for divorce is filed under section 13 of the act on certain grounds, before proceeding to grant any relief, the court in the first instance should make an endeavor to bring about reconciliation between the parties. So it says in the same language which the section says, the Honorable Supreme Court affirms the verdict of the section by saying that it is the duty of the court to make an efforts to amicably settle the dispute between the parties. Another very important judgment is of the Supreme Court is K. Srinivas Rao versus D.A. Deepa, delivered on 22nd of February 2013. It's a really very important judgment, so I would like to read the important observations. We therefore issue directions which the court, while the court dealing with the matrimonial matter shall follows. So they have settled the principles for all the courts. In terms of section 9 of the family code, the family code shall make all efforts to settle the matrimonial disputes through mediation. Even if the counselor submit a failure report, the family court shall, with the consent of the parties, refer the matter to mediation center. In such a case, however, the family court shall set a reasonable time limit for mediation centers to complete the process of mediation, because otherwise the resolution of the dispute by the family court may get delayed. In a given case, if there is good chance of settlement, the family court in its discretion can always extend the time limit. Even if the period of time limit is prescribed, the family court can always extend that time limit, because the marriage should be saved. The further finding is the criminal court dealing with the complaint under section 498A of the IPC should at any stage, and particularly before they take up the complaint before hearing, refer the parties to mediation center. So even in criminal case, it is verdict of the Honorable Supreme Court that the matter should be referred to the mediation center. All mediation centers set up pre-litigation desk clinics, give them wide publicity, and make efforts to settle matrimonial disputes at pre-litigation stage. Direction is also given to all mediation center that the efforts should be made to settle the matrimonial dispute at pre-litigation stage. So in today's video, we have learned that how it is binding that the family court should make first efforts, and parties should also make efforts so that their marriage should not be dissolved and they live happily in the matrimonial home. I would like to conclude this video. Thank you so much, friends.